Hello everybody, my name is Celestin Matt, and today I'm going to talk to you about the work we did at INRIA with Natalia Bielova and Cristina Santos on cookie banners and consent. The title of the talk is Do Cookie Banners Respect My Choice? Measuring Legal Compliance of Banners from IAB Europe's Transparency and Consent Framework. So, as you may know, in May 2018, the GDPR came into force. This new law introduced new rules regarding the consent for the collection of personal information, along with potential bigger fines. As a consequence, the industry organized themselves, and an association of advertisers called IAB Europe proposed a technical solution for the collection of consent called the Transparency and Consent Framework, or TCF for short. In this talk, I'm going to describe this framework, then detail the violation that we found, and then explain how we crawled this to find them on a massive scale. But first, as a background, I need to describe the classical business model of the web. In this model, publisher will publish content, for free or not, to users, and because they want to get revenue out of this content publication, they will include third-party content from advertisers in exchange of revenue, and this advertiser will take advantage of this position to track users and collect their personal information. Now, the TCF introduces new actors called Consent Management Providers, or CMPs for short. The publisher will include scripts from the CMP, which will be responsible for displaying a banner to the user. At some point, the user will give an answer to this banner, and the CMP will communicate the consent to advertisers. So to sum up, the CMP is responsible for collecting and disseminating consent. To give you an overview of the websites on which the TCF is used, here is a list of top websites on which we found the TCF, sorted by their ranking in the Tranco list. You may recognize some websites you know, such as msn.com, The Guardian, W2 School, etc. So, what does this framework contain? It defines a couple of things that I'm going to describe in the following slides. First, standard purposes of data processing. Secondly, an API to standardize communication between CMP and advertisers. Next, a consent string format. Then a so-called global vendor list, that's to say a list of advertisers, and a global CMP list, along with other APIs and mechanisms. First, it defines standard purposes of data processing. There are 5 purposes with a short name such as information storage and access, personalization, and so on, and then a long description which is supposed to explain clearly what this purpose is about. These purposes of data collection will be shown to users in the banners, and these users will have the possibility to customize their choice for each purpose. The second thing that the TCF defines is a JavaScript API to standardize the communication between CMPs and advertisers. These specifications are public, which allows us to study the communication between the CMPs and these advertisers. But I'm going to describe this a bit later. The third thing defined by the TCF is a format for storing the consent given by the users on banners, called the consent string. This format is basically a base64 of an array of fields, and once again, since this format is public, this allows us to decode it and understand what's actually going on behind these banners. Once advertisers are registered to the TCF, they appear in the global vendor list that describes which purpose they declare to use and under which legal basis. Currently, there are almost 600 registered advertisers to the TCF version 1. Now that you know more about how the TCF works, let's move on to describing the suspected violations that we found. But first, to understand what was going on, we developed a browser extension that queries the CMPs as if it were an advertiser. This way, we can give a response to a banner like a regular user, and at the same time, query the CMP in an advertiser position. This way, we can see whether the consent string transmitted to advertiser is consistent with what the user enters on the banner. And that is not always the case, as I will show you with two demos. Our extension is called Cookie Glasses and is publicly available on GitHub, Firefox and Chrome extension stores. In the first demo, we open a new empty browser session and visit wire.co.uk. We see that there is a banner. But even before we do anything on the website or interact with the banner in any way, our browser extension detects that a positive consent has been set for two purposes and hundreds of advertisers. But the second demo is even worse. Once again, we open a new empty browser session and this time visit flashcore.com. This time we open the banner and manually unselect all choices. Even though we manually refuse everything, our browser extension detects that the positive consent is set for 5 purposes and hundreds of advertisers. We also consider two supplementary suspected violations, the first one being when there is no way to refuse tracking, to opt out of tracking, and the second one being when there is a way to refuse tracking, but the different purposes are all preselected by default. We back our study with a legal analysis by one of our co-authors who is an expert in law. The first violation that I showed you, called consent stored before choice, is in potential violation with the prior and unambiguous consent requirement, which is derived from the Article 6 of the GDPR, Articles 5.3 of the ePrivacy Directive, and further recognized by the EDPB and DPA's guidelines. The second violation that I showed you, called non-respect of choice, is in potential violation with the lawfulness principle. If there is no consent given to cookies, as required by Article 5.3 of the ePrivacy Directive, any processing thereto is considered unlawful. For the third suspected violation, called no way to opt out, this practice potentially violates the requirement of an unambiguous and free consent defined in Article 4.11 of the GDPR, which mandates that the user has a choice to either accept or refuse in a user-friendly way. Finally, thanks to the European Court of Justice Planet 49 case of October 2019, it became clear that preselected choices do not constitute a valid consent. Once we identified these 4 suspected violations, we wanted to detect them on a large scale, and this is why we started crawling. As I mentioned earlier, we take advantage of the fact that the JavaScript API is open to automatically and semi-automatically detect violations on websites. For this, we built a Python tool called CookieInspect, which is also publicly available. Now, let me guide you through this figure. We first use the trunker list to select the top 1000 websites for each top-level domain of a European country, plus .org, .com, and .eu. We first crawl this website and detect automatically which one of them use a TCF cookie banner. We identify 1426 such websites. Then, still automatically, we detect the consent stored before choice violation, along with other information which are described in the paper. Then, we select websites of countries whose language we speak, and detect semi-automatically the no way to opt out, preselected choices, and non-respect of choice violation. In the second semi-automatic crawl, we manually respond to banners. We obtain the following results. The first interesting information is the list of the most popular CMPs. You may recognize some of them if you're used to clicking on banners such as Quantcast, OneTrust, or Didomi. The second interesting information is the results regarding the different suspected violations. We observe the consent stored before choice violation on 65 websites, the no way to opt out on 38 of them, the preselected choices on almost half websites, which is shocking, and the non-respect of choice in 27 websites. In this slide, I show the list of those websites on which we saw the different violations at the time of the crawl in September 2019. So for instance, we found the consent stored before choice violation on msn.com or wired.co.uk and other websites, the no way to opt out violation on slate.com, preselected choices on a lot of websites, for instance w3schools.com, and a non-respect of choice violation on reuters.com. You may recognize websites that you know and visit often. You are probably wondering who is responsible for these suspected violations, CMPs or publishers? Well, there is no easy answer to that. As you can see in the results table, we often find suspected violations in a fraction of websites using a given CMP. This is because CMPs often propose different banner scripts with different legal implications and leave the choice to publishers proposing to, quote, optimize consent collection or maximize user opt-in. We argue that CMPs and publishers have a joint responsibility for the suspected violations. So, as a conclusion, let's sum up the talk. We studied websites using IAB Europe's Transparency and Consent frameworks. We crawled 1,426 websites automatically and 560 websites semi-automatically, and we found violation of the GDPR in more than half of them. First, we see that 141 websites register consent before user choice, 38 websites offer no way to opt out, 236 websites pre-select choices, and 27 websites don't respect user choices. We back all these violations detection with a legal analysis. Of course, there is more in the paper, so I encourage you to read it. As a follow-up to this work, the NUB Association, which already managed to have Google pay a 50 million fines in January 2019, filed a complaint against 3 publishers. They use our Cookie Glasses browser extension to observe the non-respect of choice violation on websites of the 3 publishers. As of May 2020, the CNIL has not given a response to this complaint yet. Thank you for your attention. I'm ready to take questions if you're watching this during the live session. Otherwise, there is our contact information, so feel free to send us an email or contact us on Twitter if you have questions. We are looking forward to your questions. Bye.